Friends, Namaskaram. Today I am going to discuss an important perspective of CBI investigation and the recent legal position that has been propounded by Honorable Madras High Court to protect your legal rights from being managed and being infringed by the approach of CBI officials. So, if you want to learn really, it is a great time. So, have a patience, have a peace with you, and apart from that, you are required to have a copy and pen with you so that whatever I'm going to narrate you could note down the same and could internally apply the same in the conceptual manner in your case so that we could have a success. Okay, are you ready? Okay. Friends, the concerned topic is concerning with the banking official. As we know that being a bank official, sometime we might be implicated in a forgery case, in a cheating case, in the case of criminal misconduct on the ground that we have misused the banking norms, inter alia disbursed the heavy amount of loan, and inter alia we have given the loan to those persons. Definitely, from the time of sanctioning and disbursement, it is in our best knowledge that the amount will not be refunded back by those beneficiary, but despite of that, it has been disbursed. So in that scenario, on the point of intention, mens rea, we usually booked in the case of cheating, forgery, section 131D of PCA that is concerning with the criminal misconduct. So how to defend, how to win such cases, it is a basic point which is going to be discussed by me in the present class. Okay now, so note down at the top CBI trap concerning the cases wherein the bank officials are implicated on the ground that they have dispersed huge loan amount without doing the proper banking norms verifications. Okay, na? That is a primary consideration, that is a basic problem on which we are going to discuss. Friends, the said problem had been discussed by Honorable Madras High Court recently, and inter alia propounded a judgment. That is, inter alia belongs to April 2025. In that case, there were certain persons who had been arraigned as an accused. Maximum of them were official of bank, and some of them are the concerned persons who inter alia took benefit from the bank in the form of loan facility, including the other instrumentations. And apart from that, the allegation of CBI is that while doing the same, they are having the mens rea, means the bad intention. They inter alia prepared the forged document. They inter alia fabricated the documents, and ultimately the bank funds had been misappropriated. And apart from that, a loss of crores had been caused to the concerned bank. And apart from that, certain fictitious company had been created. Apart from that, to provide them the better OD facilities, fictitious valuation certificate had been prepared, submitted, and ultimately loss had been caused to the bank. And in the whole process, they were conspired, they are having collusion, it resulted in a huge wrongful loss to the concerned bank. Ultimately, CBI in the case had lost the FIR. Ultimately, some of the accused had been dropped, some of the accused had been arraigned as witness, and some of the accused had been accused in the present case. I am emphasizing on this point because I think that it is a casual approach of the CBI as observed by Honorable Madras High Court. Why you are having such approach? The court emphasized that it is basically a prime investigating authority in our country. Whenever we are having a very serious case, the case in which we are having no hope to get justice is usually investigated by CBI so that the right position, the right thing could be on record and the concerned victim could get justice. But having such approach means pick and choose formula is not justified, and such approach is against the basic norm of the criminal jurisprudence. The court emphasized that it is a time wherein the concerned CBI has to work on certain guidelines which we are going to advise them. In the said case, the concerned court advised CBI to follow these guidelines to have the proper investigation because the fair investigation is part and parcel of Article 21 of Constitution of India. It had been emphasized. In the present case at hand, the concerned accused person had been charge sheeted. The charge sheet was under Section 420 of IPC with Section 471, Section 468 of IPC with Section 120B of IPC with Section 13 subclause 1 subclause D of PCA. The prime allegation of the CBI is that the accused persons were conspired. They were hand in glove. Apart from that, they committed forgery. Apart from that, they committed criminal misconduct, resulted in the huge loss to the concerned bank. In the entire proceeding, the concerned trial court inter alia convicted some of the accused, inter alia acquitted some of the accused, and ultimately the accused persons who are convicted inter alia preferred an appeal before the Honorable High Court. The prime attack of the accused persons who are convicted is that in the present case, we are having multiple accused, but on same set of evidence, some of them are acquitted and some of them are convicted. And the said approach of the concerned trial court is against the settled norms of criminal jurisprudence, which internally emphasize on principle of rule of parity. It is submitted that the prime allegation against us is that there is fabrication of record, and apart from that, forged certificate regarding the valuation had been generated, submitted. But the key point is that the concerned evidences, means scientific evidences to sustain the same, is not available on the record, and apart from that, their prime contention is that no scientific evidence had been examined by the concerned prosecution agency to stand that the alleged forgery had been committed by the accused person. As we know that even though the report is on record, the concerned authority who inter alia gave the opinion is required to be examined concerning the same. Honorable Supreme Court in case of Keshav Datta versus State of Haryana had propounded the detailed guidelines. Apart from that, the prime attack of defense is that the approach of concerned officials of CBI is totally biased, because on same set of evidences some had been dropped, some had been added as witness, and accused had been added as an accused. Is it justified? It is a primary question to the concerned CBI which they totally failed to answer. They submitted that in the present case at hand there is no fair investigation, rather than there is a mere investigation, in consequence of which we had been implicated. It is a basic presumption of criminal jurisprudence that every accused shall be deemed to be innocent unless proven guilty. But the approach of concerned CBI is totally biased. They submitted that we never submitted or issued or dispersed any fictitious loan, even there is no diversion, even we involved, and even we are not involved in any criminal activity. And apart from that, whatever loan had been given had been settled. So in the present case, there is no illegality, no crime had been committed, but CBI, by its narrow scope investigation, by its biased approach, inter alia added us as party. Ultimately, while looking to the facts and circumstances, Honorable Appellant Court, means Honorable Madras High Court, came to the conclusion that the motive of the crime is the overvaluation, fabrication, forgery, so that the maximum amount of loan could be dispersed with a view to not repay the same. And ultimately, the ultimate aim of the accused person was to cause wrongful loss to the bank and wrongful gain to themselves. So, in the entire process, what they have done, creating the fictitious entity, overvaluation of the property, creating false report, loan facilities availment without any due verification of KYC and spot verification, and apart from that, there is a case of money diversion, means the loan diversion. So, to sustain all the points, it is a duty of prosecution to put on the record the evidences by the virtue of which the court could draw the conclusion. As we know that in matter of forgery, cheating, and criminal misconduct as defined under the PC Act, there is no presumption. When there is no presumption, then it is a duty of the prosecution to prove the case beyond doubt, and if they are not able to stand on board the connecting evidence in that scenario, it could not be assumed that the accused is guilty. And apart from that, we must remember in our mind that even there might be a presumption, but despite of that, the accused is not bound to stand the defense beyond the reasonable doubt. Accused is bound to raise the probable defense, by the virtue of which it may create a doubt in the case of prosecution, and concerning the same, he may do the cross-examination, or in the defense, he may bring the extraordinary circumstances to stand the defense. So in the present case, the concerned prosecution totally failed to stand all these points, and apart from that, on same set of evidences, some of the accused had been acquitted, some of the accused had been convicted. The said approach of the concerned court is against or contrary to the settled principle of criminal jurisprudence and rule of parity. And apart from that, the material document to stand the case had not been produced, the material witnesses had not been examined, and apart from that, the connecting evidences are not on record, and the loan account had been settled, and after settlement of account with a great delay, if inspections are conducted and If any irregularity is found to the concerned official of bank, in that scenario, it could not be said that they are genuine in their approach. It might be a great irregularity, because whatever the allegations are going to be imputed are to be proved by the prosecution by having the supporting and corroborative evidences. On mere surmises, we could not have a case on board. The court specified that it is a fit case where the concerned prosecution totally failed to specify the case, and apart from that, the concerned accused raised the probable defense. The defense is the material document had not been produced, the material witness had not been examined, and apart from that, there is no connecting evidence. The loan is settled, and after that, the proceeding is done. And the prime attack is that no wrongful loss had been sustained to the concerned bank. In absence of material evidences, material scenarios, it could not be said that the concerned accused persons are killed. So, looking to the facts and circumstances, the court acquitted the accused and inter alia passed adverse remark against the CBI. So, the present case inter alia set an example for the accused persons, and inter alia by the said case we are about to learn the 5 important points. The point number 1 is that whenever there is a FIR, there is no need to worry. Read the FIR and make the proper reply. Number 2, review your case properly. Number 3, even though allegations are serious, but the concerned facts must specify the violation. Number 4, if the approach of CBI is of pick and choose, then you may sustain the objection. And apart from that, if they are going to arrest you and if they are going to mount pressure on you, then you may raise the objection even before the concerned court in light of Supreme Court judgment, that is 2016 SCC page 277. So these are the important guidelines for you. Follow the same and have the proper immunity in your favor. See you in the next video. Till then, Jai Hind, Jai Bharat.